Senator Natasha Akpoti-Uduaghan was barred from entering the Senate yesterday after Justice Binta Nyako of the Federal High Court ruled in favor of her, voiding a 6-month suspension from the Senate. The suspension was imposed due to allegations of a sexual harassment against the Senate President Godswill Akpabio. Well, joining me right now to discuss this is Emmanuel Sogo, is the counsel to the Senator Natasha Akpoti-Uduaghan. Thank you so much for your time. It's great to have you here, sir.
Thank you for having me on the show.
All right. Nigerians yesterday saw, to a very large extent, what I call it, the drama that unfolded, at the premises of the National Assembly yesterday, where Senator Natasha was actually, barred, so to speak, from entering, the Senate. She has described this, in spite of a court judgment, as an act of contempt of court order by the Senate. I'd like you to please walk us through what we're looking at.
Sorry, I didn't get the last part of the question.
The senator described, prevention from entering the floor of the Senate yesterday as a contempt of court, by the Senate. From a judicial standpoint, can you please elaborate?
Yes, the words of the senator are actually the correct position of the law, particularly with respect to the fact that there's a subsisting court order that has asked the Senate to actually reinstate her as a matter of fact, by virtue of the fact that the suspension ab initio is actually excessive. So once the court finds that the suspension is excessive, the court has gone further to actually make a positive pronouncement in that regard, to the extent that the Senate should exercise its powers to actually recall the senator in light of the fact that the suspension is actually excessive. Now, mind you, what the Senate is actually using as a loophole with respect to the order is the fact that the court used the word should as opposed to the regular word that we are all aware of, which is the use of the word shall. But that does not change the characterization of the order in question, because the order is still binding. As a matter of fact, if you look at the interpretation or the meaning of the word should, it is actually the past tense of shall. So it is still binding on the Senate. So the Senate ought to actually obey, and particularly because the order is declaratory in nature. Now, for declaratory orders, they take, they come to life forthwith. They are enforceable forthwith. You don't try to stay a declaratory order of the court. So essentially, the senator was right to have said that the Senate is actually flouting the orders of the court to have not allowed her get into the Senate chambers.
All right, because just to pick from what you said, the Senate actually did dispute the court's interpretation, stating that the judgment was pretty much non-binding and advisory, and that it only suggested that the Senate considers amending its standing orders, and reviewing it. What would be your reaction to this?
Just like I stated initially, it is not a condition. It is not in an advisory nature. The orders are not advisory in nature. It is actually a compulsion. As a matter of fact, the beginning of the order is, if you look at the enrolled order, which we have been privileged to look at, it started with the note. It says, it is hereby ordered. That is the beginning of everything. It is hereby ordered. So whatever thing that comes after that becomes an order, whether or not it used the mandatory word, which people are aware of, which is the word shall. And mind you, what the court actually said before making the orders talked about the fact that the suspension is actually excessive and it offends the provisions of the Constitution. Now, if you look at Section 1, sub 3 of the Constitution, it talks about the fact that where any act, any law is inconsistent with the provisions of the Constitution, that other law, to the extent of its inconsistency, is null and void. So to that extent, it goes without saying that once a court of law has made a pronouncement that a particular act is inconsistent with the provisions of the Constitution, it means, therefore, that whatever thing that follows thereof is null and void. So what the Senate is actually doing is just playing to the gallery because those orders are actually binding on them.
All right. One thing the senator did make known is that she would still go further to seek legal redress on this matter. What's the update on this?
Sorry, I didn't get that.
As regards, still pursuing this matter, seeking legal redress on this, the senator did make this known. What's the update, sir?
Sorry, I still didn't get you. Could you reiterate?
Can you hear me now?
I can hear you.
Okay, so one thing we understand is that the senator actually vowed to take legal action on this, by consulting with a legal team. I'm asking, is there an update on this?
Oh, to that extent, I mean, we've actually filed an appeal on our end, challenging the part of the decision that we consider to be unfavorable to the interest of our clients, to the extent particularly the one that deals with the content that the court actually found the senator in contempt of the orders of the courts, particularly with respect to the fact that she made a satirical apology while the matter was subsisting. So that is the part of the judgment that we've actually concentrated on to actually appeal against that finding, because if you look at the context of the orders that the court made with that respect, it is actually punitive in nature because it is quasi-criminal, and the court has proceeded to actually issue a fine in that respect. So it is very important that the senator actually goes to the Court of Appeal to actually clear her name to that extent, because the findings of the court were not born out of a place of fair hearing, because once anything that has to do with a criminal allegation, you have to give the person a right to a fair hearing. But in this case, that was not done. And that is particularly one of the grounds that we're trying to challenge at the Court of Appeal, that the requisite forms were not issued when it comes to the issue of contempt. The forms 48, 49 were not issued. The senator was not asked to purge herself to actually give a proper explanation of what she understands by the configuration of the orders of the court. So to that extent, we're challenging the orders of the courts, that the decision or the orders of the court were not necessarily in relation to the satirical apology that our client made. It was actually with respect to the sexual harassment, and the matters before the court, my Lord Justice Binta Nyako, were with respect to our referral to the Ethics Committee. So it is to that extent that we are trying to make that bifurcation to state that the issues are different and the senator was not actually in contempt. So that's why we're proceeding to the Court of Appeal.
All right, thank you so much. We'll go on a quick break. Once we return, we'll definitely dig deeper into this conversation. Stay with us, we'll be right back. Many thanks for staying with us. It's still Politics HQ on News Central Television. And I still have my guest with me, Barrister Emmanuel Sogo, is a counsel to Senator Natasha Akpoti-Uduaghan. It joins virtually. Thank you for your time, sir. Let me ask on a pretty, well, I call it a human perspective now. You've worked closely with the senator, that Senator Natasha Akpoti, doing all of this ordeal in trial. How would you describe, her handling of this scenario, from a human perspective, in terms of how she's taken it? How would you describe her strength?
Okay, thank you very much. I would say the senator has done pretty well, particularly because she has actually followed the due process of the law in everything that she has done right from the beginning. She actually, particularly when she perceived that her rights were going to be breached, she didn't do anything out of the ordinary. She approached the court to actually seek the enforcement of her rights, and that's the proper thing to do. And right from that moment, she has actually followed every process through up to this level, particularly even when the decision of the court came to the fore. She has actually went to the Court of Appeal to actually see how she can further ventilate her grounds. Basically, I believe she has handled it pretty well.
Saying that, I mean, in terms of the evidence she has said she has, even though in some interviews she said she will release it in due time. My question to you is, how soon will that be?
Sorry, I didn't get that.
Talking about the evidence, you know, on this matter that the senator said she has, some Nigerians, you know, who have been following this are pretty much interested as to when or how soon she would release this evidence.
Okay, thank you very much. So I'd like to just put it in context, because when it comes to issues of law, the evidence is not to be put forth in public. The evidence is supposed to be presented in court to actually allow the court to look at the issues dispassionately and arrive at a just decision. So at the appropriate time, the evidence will be presented in court. The court will decide one way or another. So this is just to tell the public who are expecting her to come to the public with whatever form of evidence that she has. No, it is not a court of public opinion. She is actually going to present the evidence in court at the appropriate time, and the public will know of how things will go from there. Thank you.
All right, and just for you personally, to Barrister Sogo, would you say that so far, in pursuance of justice on this case, would you say the judicial system so far has been fair to you, to your team?
Well, I wouldn't agree. I would say the system has not been fair, particularly with how things happen in the first court, because this particular matter was actually before another court, before the court actually recused itself on the basis of an application that was filed by the Senate President alleging some form of bias that was not even established. At that point in time, there were motions that were ripe for hearing, particularly a motion for mandatory injunction that the court ought to have taken in light of the fact that there was a blatant defiance of the court orders, the interim orders of the court. But then again, the court did not take all of those motions. The second defendant in the matter actually filed a motion, and the court actually countenanced that motion in light of the fact that our motion was first in time. So that is one of the issues, and particularly the one before my Lord Justice Binta Nyako. We had our motion for mandatory injunction. It was not countenanced, but the one that deals with the contempt, the alleged contempt of our client, was taken. So I wouldn't say the system has entirely been fair, and that is why we're going to the Court of Appeal to actually see how we can right all these wrongs.
All right. What would be your message to Nigerians and you know, supporters of the senator who are rooting and hoping for justice?
Well, I would say Nigerians and every other person that is hoping for justice should not give up, despite the fact that people will think that the system is not fair. We believe that if we keep fighting, one day things will be better. And if we stop fighting, there's no way we'll get justice at the end of the day. So we just have to keep pushing.
All right. Thank you so much for your time on the program. We deeply appreciate your time. Thank you so much for the audience.